To the newsroom, California cannot ban gun owners from having detachable magazines.
That law was unconstitutional, but the ruling will not take effect immediately.
Even law enforcement officials have told me and told other champions of this legislation.
California cannot ban gun owners from having high-capacity gun magazines, a federal judge.
But after Republicans let the law expire in 2004, and those weapons were allowed to be sold again.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
It's 2024, and a total ban on rifles and mags means that millions of arm owners may now be technically criminals. Series of court challenges. It has been decided by a federal appeals court in the United States that a legislation that was established by the state of California that prohibits the carrying of arms in the majority of public places is legitimate. The injunction that was imposed on December 20 by a judge who came to the conclusion that the law passed by the Democratic-led state violated the right of residents to keep and bear arms as outlined in the Second Amendment of the United States Constitution was suspended on Saturday by the 9th United States Circuit Court of Appeals. The law is scheduled to go into effect at the beginning of the year 2024. An administrative stay was given by the three-judge court, which placed the injunction on hold until a different panel of the 9th Circuit can examine whether or not to issue an even longer delay while the dispute is being played out. It was enacted after a landmark ruling in June 2022 by the conservative majority United States Supreme Court that expanded arm rights nationally. The bill, which was scheduled to take effect on January 1st, after being signed into law in September by California's Democratic Governor Gavin Newsom, was enacted after the ruling. The rigorous arm licensing regime that had been in place in New York was overturned by the Supreme Court in that decision, which offered a broad reading of the Second Amendment, which is the foundation for armed rights in the United States. The decision, which was made in the case of New York State Rifle and Pistol Association v. Bruin, restricted the capacity of legislators to ban the possession of arms in public places. It also resulted in a number of legal challenges being filed. The state of California, which has some of the most stringent arm control laws in the United States, was among a group of states that had restrictions that were comparable to those of New York, and as a result of the judgment made by the Supreme Court, it sought to revise its regulations regarding arms.
To the newsroom, California cannot ban gun owners from having detachable magazines.
Having high-capacity magazines, the judge says there's no American tradition of limiting ammunition capacity.
100 bullets that can be fired from that weapon.
It is the bill Ferguson has been trying to get passed since 2016. That year, a 19-year-old used a high-capacity rifle.
But California Attorney General Rob Bonta argues they aren't necessary for private self-defense.
No matter whether or not they had permits to carry concealed weapons, individuals were not permitted to carry concealed arms in any of the 26 categories of sensitive places that were included in the new law in the state of California. These sensitive places included hospitals, playgrounds, stadiums, zoos, and places of worship. The law, which was referred to as Senate Bill 2, also prohibited individuals from carrying concealed arms in privately owned commercial establishments that are open to the general public. This was the case unless the proprietor of the business posted a sign stating that license holders were permitted to carry arms on their premises. The Second Amendment Foundation, Arm Owners of America, and the California Rifle and Pistol Association were among the arm rights organizations who filed a lawsuit against the new law, saying that it violated the Constitution. The lawsuit was filed by persons who were in possession of concealed carry permits. On the 20th of December, United States District Judge Cormac Carney, who was appointed by the former Republican President George W. Bush, concurred with the decision and blocked the statute until the fate of the case was determined. As Carney put it in his writing, the law turns nearly every public place in California into a sensitive place, effectively abolishing the rights of law-abiding and exceptionally qualified citizens to be armed and to defend themselves in public. which are guaranteed by the Second Amendment. Rob Bonta, the Attorney General of California, made a swift request to the Ninth Circuit Court of Appeals to put the injunction on hold until an appeal. He stated that if the bill were to remain blocked, it would result in tens of millions of Californians facing a heightened risk of armed crime. Similar legislation that has been approved by other states have also been subjected to legal challenges. According to a decision handed down by a federal appeals court on December 8, New York State has the authority to prohibit arm owners from carrying arms in a variety of sensitive locations, such as parks, zoos, bars, and theaters. California's arm ban is unconstitutional. A federal judge who had previously invalidated California's prohibition on attack rifles, which had been in place for 3 decades, did so once more. The judge ruled that the state's efforts to prevent sales of semi-auto arms violate the constitutional right to bear arms under the state's constitution. Judge Roger Benitez of the United States District Court for the District of San Diego acknowledged that powerful arms, such as AR-15 rifles, are frequently used by criminals. However, he emphasized that these arms are also held by law-abiding individuals who hold the belief that they require arms in order to safeguard themselves. The state of California posits that its attack weapon ban, the law challenged here, promotes an important public interest of disarming some mass slayers, even though it makes criminals of law-abiding residents who insist on acquiring these arms for self-defense, according to Benitez. Nevertheless, more than that is required to uphold the ban. In a decision from 2021, the judge referred to the state of California's ban on attack weapons as a failed experiment. The judge's ruling is almost identical to that decision. Benitez has consistently overturned a number of legislation dealing with arms in the state of California.
Tonight, President Biden announcing his first ever federal office of gun violence prevention.
They sometimes feel outgunned by assault weapons with large capacity magazines.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
Ruling that law was unconstitutional, but the ruling will not take effect immediately.
For that 10 years we had it done, the number of mass shootings actually went down.
Simply 1 month ago, he issued a ruling that stated the state is not permitted to prohibit arm owners from possessing detachable mags that store more than 10 rounds. Benitez's most recent judgment would result in the repeal of a number of state statutes that are associated with attack weapons. In order to appeal the decision to the United States Court of Appeals for the Ninth Circuit, the judge gave the state 10 days to submit a request for a stay of the finding. Rob Bonta, the general attorney for the state of California, stated that his office had already submitted a notice of appeal. Within a statement that was released, Bonta stated that weapons of war have no place on the street of California. Attack weapons in the state of California can still be considered illegal. A counsel for the plaintiffs who filed a lawsuit to invalidate the statute, John Dillon, expressed his satisfaction with the judge's decision. The court's decision is constitutionally sound and addresses that many inadequacies of the state's arguments and so-called justifications for this unconstitutional ban, Dillon stated in a press release. We will continue to fight for our plaintiffs' Second Amendment rights through any appeal until the state is forced to start respecting these rights. Bonta had filed an appeal against the judge's decision from 2021. However, before the matter could be decided by the Ninth Circuit, the United States Supreme Court released a decision in a case from New York that established a new precedent for how courts should assess arm regulations. Benitez's previous ruling was overturned by the Ninth Circuit Court of Appeals, and the matter was returned back to him for him to re-examine in light of the new standard. Once more, Benitez came to the conclusion that the ban violated the Constitution. In addition, he revisited an analogy that he had previously presented. in which he compared the AR-15 to Bowie knives. Just like the Bowie knife, which was often carried by both civilians and troops in the 1800s, attack weapons are not only dangerous, but also helpful. However, in contrast to the Bowie knife, the Supreme Court of the United States has stated that there is a long tradition of widespread lawful arm ownership by private individuals in this country. As Berettas noted, attack weapons were originally outlawed in the state of California in 1989, and the law has undergone numerous revisions since that time. In 2021, the Office of the State Attorney General argued that attack weapons, as defined by the law, are more dangerous than other types of arms. They are also used disproportionately in crimes, mass layings, and against law enforcement, which results in a greater number of casualties. Therefore, prohibiting attack weapons further the state's important public safety interests. The case was filed by the San Diego County Gun Owners Political Action Committee, the California Gun Rights Foundation, the Second Amendment Foundation, and the Arms Policy Coalition is one of the several lawsuits that have been brought by arm advocacy groups challenging the arms rule of the state of California, which are among the most stringent in the country. This petition was submitted on behalf of arm owners who want to utilize high-capacity mags in their legal rifles or pistols, but have stated that they are unable to do so since, according to California law, doing so would transform their arms into illegal attack weapons instead. The plaintiffs claim that semi-auto rifles are allowed in 41 states, despite the fact that they only fire one bullet each time the trigger is released, while military weapons discharge multiple bullets.
Members of Congress are also trying to answer what the Attorney General just called the most difficult question in a democracy.
Even law enforcement officials have told me and told other champions of this legislation.
The law, also known as SB 2, bans people from carrying guns in 26 places.
For removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
In most public places, even with the concealed carry permit, is now in effect, even as the case makes its way through the courts.
Illinois attack weapon ban. The United States Supreme Court has decided not to prohibit a bill that will implement a ban on the sale of semi-auto attack-style rifles and large-capacity mags in the state of Illinois beginning the next year. An emergency motion that sought to stop the law while the justices decided whether or not to hear an appeal was denied by the Supreme Court without any justification being provided. Those who made the plea were an arms dealer who had previously been unsuccessful in a similar Supreme Court bid in May. In addition, the challengers attempted to overturn a Naperville ordinance that prohibited the sale of attack weapons, arguing that the limits violated the Second Amendment of the Constitution. Advocates for armed rights are attempting to extend the judgment of the Supreme Court in 2022, which created a stringent new process for evaluating limitations and declared the constitutional right to carry an arm. The conservative majority of the court stated that those who advocate for stricter arm rules must be able to demonstrate a historical precedent of limitations of a comparable nature. The justices who are now serving their terms are deliberating over whether or not to implement a federal arm ban for individuals who are subject to restraining orders for domestic crime, following a slaying incident that occurred in 2022 at a 4th of July parade in Highland Park, Illinois, in which a shooter armed with a semi-auto AR-15 rifle and 30-round mag murdered 7 people and injured scores more. The state of Illinois decided to pass a ban legislation. The statute was affirmed by a federal appeals court located in Chicago. The National Association for Gun Rights and arms dealer Robert Beavis submitted a request to the Supreme Court, which resulted in the court's refusal to grant their motion. They are a member of a larger group of opponents that filed a lawsuit in order to contest the bill that was passed in Illinois. The law in Illinois allows individuals to keep arms that they already possess, but beginning in the following year, it will prohibit the possession of new attack weapons. A case with a case number 23A486 is the National Association for Gun Rights versus the City of Naperville.
California cannot ban gun owners from having high-capacity gun magazines, a federal judge.
Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
We are paying for these weapons of war on our streets with the blood of our children.
I know this has been a hobby horse of mine for a long time. Got it done once.
Ruling that law was unconstitutional, but the ruling will not take effect immediately.
Supreme Court denies emergency injunctions. We're going to discuss how millions of law-abiding Americans could potentially become felons simply because they own a rifle and ammunition mags. In Illinois, millions of people now face the risk of serious criminal convictions due to 7th Circuit courts choosing to directly contradict the rulings of the Supreme Court. What's even more concerning is that the Supreme Court has declined to hold these lower courts accountable for their direct violations. Recently, we received news from the Supreme Court indicating that they denied 2 emergency injunctions. These injunctions sought a temporary halt on the implementation of the statewide rifle mag ban in Illinois, set to take effect in 2024. The Supreme Court was petitioned multiple times to intervene and temporarily stop the enforcement of this law. However, the Supreme Court chose not to take action on these requests. The cases that are being referred to here are the Nag v. Neal case and the Calkins v. Pritzker case. Both of these cases featured a judicial challenge to the Protect Illinois Community Act, PICA, which, among other aspects, puts limits on rifles and mags that are considered to be illegal. In addition, the PICA includes a registration requirement, which is essential for grandfathering in arms that were legitimately and legally acquired prior to the adoption of the government law. Regrettably, the time for registration has now passed, which means that the opportunity to register arms that were previously owned is no longer available. As a consequence of this, the ownership of these objects will be considered illegal beginning in the year 2024, and individuals will be liable to severe criminal penalties. In order to better understand the potential repercussions of the challenges that have been brought against PICA, let's go deeper into the specifics of these cases. During the course of the Sense case, the legal action was initially brought before a lower court in the state of Illinois. After being reviewed, the court issued a summary judgment against the state of Illinois. A violation of equal protections under the law was cited as the motivation for this judgment, which deemed the ban to be unlawful. This initial triumph was placed within the bounds of the lower court of the state of Illinois.
Saturday, a federal appeals court put a temporary hold on the district's judge, ruling
that they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
But after Republicans let the law expire in 2004, and those weapons were allowed to be sold again.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
Of domestic abuse, you shouldn't have a gun. If you're on social media threatening the lives of people, you shouldn't have a gun.
Concerns have been raised over the wider implications of these court battles and the potential impact they could have on the rights of law-abiding arm owners as a result of the situation. The Supreme Court's refusal to grant relief in the form of emergency injunctions is indicative of a complicated legal environment, one in which challenges to restrictive arm regulations encounter major obstacles. As these lawsuits continue to move forward, it is going to be interesting to observe how the legal system will deal with the conflict that exists between state rules and constitutional rights, particularly those rights that are safeguarded by the Second Amendment. State and federal courts in conflict. In the beginning of a large legal battle, a state court came to the conclusion that the rights to bear arms included in both the state constitution and the federal constitution are fundamental rights. As a consequence of this, the legislation that was being challenged was submitted to a rigorous examination, which the legislation did not meet the requirements for. The Protect Illinois Community Act, PICA, was declared null and unlawful by the state's lower court, which ruled that it violated the American Constitution. In spite of this, the state of Illinois filed an appeal against this ruling, which ultimately resulted in the Illinois State Supreme Court overturning the verdict. Concerns have been raised about the possibility of financial contributions being made to two justices on the Illinois State Supreme Court who are personally involved in the case, which has led to doubts questioning their impartiality. Immediately after the ruling was handed down by the Illinois State Supreme Court, the plaintiff filed a petition of certiorari in an effort to seek redress from the United States Supreme Court. Following the acceptance of the waiver, the United States Supreme Court has scheduled a conference to be held on the matter, which is slated to take place on January 5th. While this was going on, the plaintiff in the Calkins case pursued an additional emergency state request that was pending review by the Supreme Court. This request was explicitly directed to Justice Barrett. In this urgent request, a stay on PICA was requested until the United States Supreme Court considered the matter on January 5th.
In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
Also ban assault weapons and high-capacity magazines in this country.
This is a violation of that federal law. The federal judge that initially ruled in this agreed, saying it's up to Congress.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
Including public parks and playgrounds, churches, banks, and zoos.
On the other hand, Justice Barrett issued an order that rejected Cogan's application and declined to put the emergency state request to a vote by the entire court. The NRV Naperville case provided a distinctive stance, which occurred concurrently with the creation of the law. An en banc petition was still pending in the 7th Circuit Court of Appeals, despite the fact that the Supreme Court had been asked to provide emergency review and relief. It is unfortunate that the 7th Circuit Court of Appeals did not grant en banc review for several PICA lawsuits, which further complicates the legal situation surrounding the ban on rifle mags. However, in the end, the United States Supreme Court decided not to grant emergency relief in either the NRV or the Cogan cases, which indicates that the court is reluctant to act at this preliminary level. This recent order from the Supreme Court highlights the difficulties that those who are challenging the Illinois rifle mag ban are facing, the legal complexities and jurisdictional nuances that are playing a big role in the unfolding legal drama are contributing to the complexity of the situation. Examining the aftermath and future options. Concerning Nagar's request for a writ of injunction pending certiorari, the Supreme Court recently denied the plea, which has led to the emergence of intriguing questions. The ongoing legal drama is made more complicated by the fact that there were no dissenting opinions expressed in any of these denials, including the one regarding the Cogan case. Nagar, in spite of this loss, continues to have a number of alternatives available to them, including the potential of filing a writ with the Supreme Court. This is especially true given that the 7th Circuit en banc panel declined to review their case. Rather than conducting a complete examination of the merits of the case, it is essential to keep in mind that such a review would be interlocutory, with the primary focus being on whether or not a preliminary injunction ought to have been granted.
California cannot ban gun owners from having detachable magazines that hold more than 10 rounds.
For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past.
Nobody can seriously argue that you have to have this kind of a weapon for self-defense.
That we passed in 1994 with bipartisan support in Congress and the support of law enforcement.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
On the other hand, the Calkins case, which was decided based on a motion for summary judgment, has the potential to be subjected to a final assessment of its merits if it is brought to the Supreme Court of the federal government. Taking this into consideration, the relevance of Cogan is elevated within the larger framework of the fight against the Protect Illinois Community Act, PICA, in Illinois. In an effort to circumvent the review conducted by the 7th Circuit, and the recent denials made by the Supreme Court, the FFLV Pritzker case requested a fresh preliminary injunction from Judge McGlynn. This was done in response to the last-ditch effort that was unsuccessful in the lower courts. On the other hand, Judge McGlynn turned down this fresh request for an injunction, citing the limitations that were imposed by precedents decided by higher courts. In spite of this, he stated that he intended to speed up the review of the case so that it may proceed to the merit stage, which would open up a potential possibility for additional legal investigation. As a result of these legal maneuvers, millions of arm owners in Illinois are now in a position where they could be subject to severe criminal penalties as a result of the recently approved prohibition on rifles and mags. A second degree of legal risk is added to the issue as a result of the expiration of the registration period, which means that arm owners are no longer able to register arms. There is yet a glimmer of hope about the Kogan case, which is due to be heard by the Supreme Court on January 5th, despite the difficulties that have been encountered. In addition to providing a last chance for a thorough examination of the merits, the conclusion of this conference has the potential to influence the course of the legal disputes that are associated with the Illinois PICA. That's all for this video, folks. See you next time.